Okay, hello folks, thank you so much. Just a quick reminder, there's no food or drink in the auditorium. You're welcome to come back in after you have had some coffee, but no food or drink in the auditorium. Thank you again for coming to the NoCal 2019 Spring Institute. And I am pleased to introduce Diane Rodriguez, who is joining us today from the San Francisco Law Library to talk a little bit about county law libraries and what has happened in the last year since our Spring Institute last year, which focused on advocacy. There have been some great developments, and so she's going to say a few words about those, and then she will introduce our featured speaker, Jamie Baker, joining us from Texas Tech, and I hope you enjoy both. Thank you very much, Diane.
Hi, everybody, and thank you, Jocelyn, for planning such a fabulous institute. This is really wonderful. First of all, I don't know how many of you were able to make it last year to the Institute in Sacramento, but David Holt put on a wonderful program that's focused on advocacy efforts, and the speaker there, who not only gave the keynote address but also offered a bunch of workshops, was Patrick Sweeney of Every Library, which is a nationwide advocacy group. It's the only action committee that focuses on libraries, and they do big campaigns across the country to help public libraries all over find funding, push big efforts, ballot initiatives, all kinds of things. So Patrick was so great. In the afternoon, David had set it up so that we coordinated a whole bunch of workshops specifically for California county law librarians and how we could do things better to push our agenda, get more funding from the state, and just do general advocacy work throughout California. And so I'm pleased to report that as a result of that institute, the California County Law Libraries are initiating a program that is starting now. It's called the Every Library California County Law Library program, where we are starting out with seed money. We have raised amongst ourselves $10,000, and now it's $12,000, I'm happy to say, to work with them. And what they're going to be doing is helping us with an awareness and advocacy campaign throughout California. So our goal is to obtain 10,000 registered Californians in support of county law libraries, so that in the future we will be able to call on them when we do our pushes for more funding from the state, for any kind of advocacy needs for county law libraries. But also with this, it's just an awareness campaign, a statewide awareness campaign to let people know, Californians know, that this resource is available to them, because not everybody knows about it. But thank you so much for putting that forward and helping us all to come together with the California Council of County Law Libraries to make this happen. So we're really excited about it. We'll probably be calling upon definitely all county law librarians, but maybe some NoCal members too, to help us write some articles about libraries and do some PR things. So more to come on that, but I want to thank everybody in NoCal for your continued support of the California County Law Library effort. We really appreciate it. Now, I'm very pleased to introduce Jamie Baker, who is the interim director of the Law Library at Texas Tech. She's well known as the law librarian community as a blogger behind the website The Ginger Librarian, which often appears in AALL's Know-It-All newsletter. It's been named as an ABA Blog 100, as well as a top 10 blog for legal researchers. I hope you've all looked at it. I look at it a lot. She's also widely published in more traditional channels, including 2 papers in 2018. One was a 2018 A Legal Research Odyssey, Artificial Intelligence as Disruptor, from the Law Library Journal, and The Duty of Technology Competence in the Algorithmic Society from the South Carolina Law Review, which is what she'll be talking about today. So please welcome Jamie Baker.
Thank you for that warm introduction. I'm so excited to be here today. So this presentation, I'm just going to get my computer set up here. This presentation, I started this research, I would say, in probably 2014. I felt like that was the time as law librarians, that's when we started to see artificial intelligence, artificial intelligence, artificial intelligence. So I wanted a better understanding of what artificial intelligence meant, and it's led me to the algorithms behind the legal research databases that we use. And so this aggregates the research that I've done to hopefully give you all sort of the base level knowledge that I currently have, and we can move forward together into the future of law librarianship into this area. So I want to start out with sort of this definition of artificial intelligence. As we all know, we're very sophisticated users. I like this crowd here. When I'm in front of attorneys, they're like much more scared of it. So law librarians are a great crowd. So artificial intelligence, as we know, encompasses many different technologies. In the broadest sense, the definition is that it refers to machines that can learn, reason, and act for themselves. Learn, reason, and act for themselves. So as I mentioned, the type of artificial intelligence that I'll be speaking about today is algorithms that we use in legal research. So the basic definition of an algorithm is a set of rules that a machine follows to achieve a particular goal. A set of rules that a machine follows to achieve a particular goal. So the search algorithms in particular that we use, they follow a procedure to determine what kind of information is retrieved from mass data, which sort of complements the discussion that Michael did earlier. In terms of data, what's the most broadly used data that we use for legal research? What would you say it is? Cases made up of words, right? So we are actually down to the word level data that we are trying to retrieve and understand through the use of algorithms. And so one of the most widely used algorithms, I use it every day, is Google, right? Google. It's a search engine, as you all know, with its own proprietary algorithm that ranks websites for keywords for what it then determines is relevant results. It's essentially what our legal research databases are doing or purporting to do today, and we're going to talk more about that in just a minute. This seems like a bit of a rhetorical question in front of this crowd, but why do we care about the use of algorithms in legal research? You think they're just giving you an answer, that's wonderful, or many attorneys think it's just giving them an answer, and that's a wonderful thing. But we're going to dig deeper into the benefits and the risks associated with those algorithms. This is where the duty of tech competence comes in. How many of you have heard of the duty of technology competence? Okay, that's good. More and more people I'm finding out have heard of this duty, so that's a wonderful thing. But when we think about what a lawyer does, the actual functions of being an attorney, what we're teaching, the research we're doing even as librarians, our interpretation of the law is built on case precedent. So we're researching, this is very foundational to all of us, researching the case precedent to create the quote unquote best argument for a client. That creation of the best argument takes a high level, sophisticated, pragmatic level understanding of language, and we're going to talk more about that in just a minute. But we're relying more and more on algorithms to do that heavy lifting for us, to decide what is relevant. And what we're going to see is what this upcoming generation, being dubbed the Google generation, born 93 and later, what their research habits are. And their research habits are that they're really just handing it over to the algorithms. They tend to only focus on the top results in the list. So we've just let the algorithms do a lot of heavy lifting in terms of deciding which cases will advance the law, okay? So let's get into the duty of tech competence. So the ABA model rules of professional conduct was amended in 2012 as part of Comment 8 to include this new duty of tech competence. So at the top here, you have the ABA model rule of professional conduct. providing competent representation to a client. An attorney requires legal knowledge, skill, thoroughness, etc. You can read that, right? Comment 8 was amended to provide, in the pertinent language here, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. Including the benefits and risks associated with the relevant technology. Now, Bob Ambrogi from the Law Sites blog, if you don't read that blog, it's a really wonderful blog to read. Bob Ambrogi keeps track of this duty of tech competence for us. It's been wonderful that he does that. And he's actually called this a sea change in the practice of law. So we know that a model rule is only as good as the states who adopt it being enforced, right? So here, just earlier this month, my state now of Texas, I have a hard time saying I'm from Texas. I'm originally from Michigan, so I'm still getting used to that whole Texas thing. Texas was the last state to adopt this earlier this month. So we have 36 states that have adopted the actual model rule, that language that an attorney must understand the benefits and risks of the associated technology. Now, we're going to see California in just a minute actually has an ethics opinion. Are any of you aware of this ethics opinion that sort of starts to interpret a duty of technology competence? So while the state hasn't formally adopted the duty, there is an ethics opinion out there that we're going to talk about in terms of interpretation. So let's talk about what this duty requires today, what we know that this duty requires today. So the outer boundaries of the duty have not yet been established. We know that law is often very behind in terms of technological advances. So the outer boundaries have not yet been established. So the current interpretations are applying to electronically stored information and data, e-discovery, social media, and the cloud, sort of where we are right now in terms of the duty of technology competence. So these interpretations are coming through guidelines from various states, advisory opinions, and actual cases that have interpreted the duty. Now you'll see that the language was left purposefully amorphous. It's a very broad standard. A lawyer must understand the benefits and risks of the associated technology. And this sort of goes to the understanding that this is going to be a changing standard. What skills a lawyer is going to need in the future, the decades ahead, are difficult for us to imagine right now. We're sort of in this interim period between traditional methods of lawyering and bringing in all of this technology and how that looks going forward. So we've got this theory of exponential acceleration, which is represented in the slide here. This offers insight into advances in information technology, right? So over the long period, we can see it's likely we're going to be maybe a singularity. We're going to look more at that in just a minute. But the short term is much more complex. It sort of goes in fits and starts, and we're at a period where we have to be flexible in that. So we know that progress is not always smooth and consistent. It's going to lurch forward, it's going to pause while we assimilate to these new capabilities. So the outer boundaries, as I mentioned, have not yet been established. So I have used the current guidelines to make analogies, make arguments for how the duty of tech competence would be applied to the use of algorithms in law. No formal guideline, no case has come out interpreting that. This is where my research starts to fill this hole, is duty of technology, competence, how should that be applied to algorithms in law? So we're going to look at 3 guidance documents, and as I mentioned, one of them is from California. So we've got the Washington Bar Association is one of the guidelines that I like to use here. So the Washington Bar Association, in a guideline, has said that a lawyer using a third-party service must conduct a due diligence investigation of the provider and its services and cannot rely on lack of technological sophistication as an excuse as a failure to do so. Additionally, from this Washington Bar Association, so this is actually an opinion, a lawyer's ethical duty regarding technology does not stop after the initial due diligence. It's an ongoing duty that requires long-term reasonable care. Analogously, when it gets to algorithms, and we're going to talk more about algorithms in just a minute, a competent lawyer should continuously monitor their use of a vendor and the corresponding algorithm, the results, to ensure that they use reasonable care when relying on the algorithm's results. Using reasonable care when relying on an algorithm's results. We're going to see why in just a minute. As mentioned, from this bar opinion, we know that the lawyer's lack of technological sophistication is no excuse. So the lawyer must at least have a basic understanding of the pitfalls associated with using algorithms, understanding the risks associated with using the algorithms, and be able to vet the content. What do these results include? Are they, say, biased, which we're going to take a look at in just a minute? We're going to get to more of those pitfalls. We all come into this. So I actually want to poll the crowd here for a minute. How many of you come from academic libraries? Okay. And how many from government? Okay. And firm? Okay. So some of you are teaching lawyers how to do this. Some of you are doing research for the lawyers and how to do this. So you end up having to understand more of the benefits and the risks and providing them good results, right? So when I say lawyer, I also often mean law librarian in this context. So we have here New York social media guidance. So this is another guideline. I talked about the duty of technology competence as applying to social media. So New York's social media guidance mentions legal research, and it says, if an attorney cannot ascertain the functionality of a website, the attorney must proceed with great caution in conducting research on that particular site. So a competent attorney complying with the duty of tech competence is going to proceed with great caution when relying on a particular website if they cannot ascertain the functionality. So when it comes to algorithms, right, the algorithms are what are driving the results. If a lawyer is using an algorithm, it doesn't matter if it's Google or Westlaw or Lexis or Fastcase or any of the algorithms at this point, but cannot ascertain the functionality of the algorithm, the lawyer must proceed with great caution when relying on the results. And we get to California. Your great state of California has a bar opinion where we see 3 options from which a lawyer should choose when confronted with an unfamiliar technology. 1, become familiar with the technology. 2, consult with or delegate to someone who is familiar with the technology. Or 3, decline to represent the client. Okay. Do you know of any lawyers who have declined to represent clients based on technology skills? Likewise, when we talk about it in terms of algorithms, a competent attorney, when confronted with an unfamiliar algorithm, so this is our unfamiliar technology, will become familiar with it by looking for patterns, such as biased results or making sure that foundational cases show up in the results list. So you have to have some understanding of that area of law. And if the lawyer cannot confidently ascertain the legitimacy of the results, the lawyer should consult with or delegate to someone who can, right? This is where we come in. We're the experts here. Have you heard of the couple of Canadian cases that have recently come out on legal research? Okay, these are interesting. So in addition to the guidance documents, we have a couple of cases from Canada that provide some insight into judicial interpretation of being compelled to perform legal research on databases, okay? So these cases out of Canada, according to one of the judges, states that computer-assisted legal research provides more comprehensive and more accurate answers to legal questions in shorter time than conventional research methodologies. Okay, so there's one of the cases is called CASS, C-A-S-S. In CASS, the judge capped the costs awarded in a personal injury case, writing that if the attorney had used artificial intelligence, broadly, AI, to conduct legal research, it would have significantly reduced their preparation time. Essentially saying they should have used AI to conduct their legal research, right? And in another case called Drummond, the defendant objected to a roughly $1,500 claim for legal research costs incurred on Westlaw. The judge in this case noted that the jurisdictions are split on allowing recovery of legal research fees, but the judge in Drummond specifically allowed the fees for legal research, commenting that CalR, computer-assisted legal research, provides a more comprehensive and more accurate answer to a legal research question in a shorter amount of time, as I mentioned. So if you use these cases to further interpret the duty of technology competence and sort of what functions a lawyer performs today, all lawyers are performing some type of legal research when they prepare a case. Either their law librarian is doing it or the lawyer themselves, right? So the major benefit, we talk about the benefits and risks of the associated technology. The major benefit of using these results are that they are more efficient and potentially more comprehensive than going to the books, especially the upcoming generation. A lot of these folks aren't even being taught how to do the research in the books, okay? But as we all know, if legal research is done properly on databases powered by algorithms, it takes much less time. And attorneys, as these judges are saying, sort of interpreting these decisions, attorneys should use these resources to ensure that legal research is performed efficiently, comprehensively, and accurately. We can all do this. If we use the databases, I would say that if I used a database, it would be more comprehensive and more accurate than if I were to go to the books today, in terms of the amount of resources that are available in my law library in print. So I think I would get a more comprehensive, more accurate answer on the databases, but you have to know how to use them as well. So we talk about Boolean searching. We're going to talk about natural language processing here in a minute. Most of our students are using keyword searches to do searching in the algorithms. Can the algorithms provide a very accurate and comprehensive result at this point? Maybe not, okay? So that's where the risks comes in. So if we talk about the benefits and the risks of the associated technology, so now an ethical, competent attorney, it looks like they should be doing research on the databases because it's more comprehensive and more accurate. But they have to know how to do it and understand the risks as well for what they're looking at. So ultimately, the underlying principle here is that a lawyer, at a minimum, must use reasonable care. And when we talk about reasonable care, lawyers should be able to recognize anomalies due to their legal training. We spend 3 years in law school to understand anomalies in results. So a lawyer should be able to recognize the anomalies in the results. They should know enough to test the answer. That's what Michael was saying, is we have to understand where the information is coming from, where the data is coming from. We have to know enough to test that answer. Asking potentially a different question, right? Adjusting the data that we're using. If the lawyer is looking, and that's the uphill battle right now. Are they just relying on that top result, or are they actually looking and questioning and understanding what it is the algorithm did to get to that result? So the lawyer has to understand the information that they rely on, providing advice to a client that is the result of the lawyer's own independent, educated judgment. It's not enough to hand it over to the algorithm to say, this is what the algorithm told me. Okay? So let's talk about the future of the duty. So we kind of know through these guidance documents a little bit more about where the duty is now, and I've made some arguments about how it would be applied to algorithms. Let's talk about more about what the future of the duty of technology competence is going to look like in what is being dubbed the algorithmic society, okay? So we have to understand the issues surrounding algorithms and use reasonable care. Okay, we were going from the information age to the algorithmic society, where algorithms are increasingly used in our professional lives, in our everyday lives. I don't go a day really without using an algorithm. How many of you would say the same thing? If you Google something, you're using an algorithm at least some point in the day, okay? So I would say it's useful to understand how algorithms will be used in law by understanding how algorithms are being used in other professional areas as well, okay? How many of you have heard of Kensho being used in finance? There was a really wonderful New York Times, almost expose on Kensho being used on Wall Street. So say that a broker, is looking to buy assets, but is concerned about a border dispute and the effect of the border dispute, the ramifications of the border dispute on the asset acquisition. So Kensho's interface consists of a small black search bar, very simple, kind of looks like Google. The broker would type in some keywords about the border dispute and get several groups of related events related to that dispute would appear, much the same way that Google's recommending queries based on past searches. Kensho is going to do research in seconds, bringing what is being touted as bringing the end user digestible information while predicting asset performance, okay? This whole process of using Kensho to determine asset performance has taken just a few minutes. Previously, generating a similar query without automation would have taken probably 40 hours from people who were making $350,000 to $400,000 per year. Just wipe them out. And on Wall Street, they're more concerned, seemingly, with the bottom dollar, right? So they're more willing to rely on the results of the algorithm than, say, in the medical field, arguably. So let's take a look at Watson for Healthcare. How many of you have heard of Watson for Healthcare? Okay. So in a clinical setting, now this is what Watson is being purported as being able to do. In a clinical setting, Watson for Healthcare is used to develop a diagnostic support tool using a set of observations about a patient's medical condition, so keywords dealing with a patient's medical condition. Ultimately, generating a ranked list of potential diagnoses with associated confidences based on searching and analyzing large amounts of evidence. So we're talking about medical literature, we're talking about electronic medical records, all sorts of data being searched. So you put in a few keywords about the patient's medical condition, giving you a ranked list of diagnoses with associated confidence levels. This is more likely, based on my research, this is more likely what we're going to see in law. So, at least purported, you put in a few keywords about a fact pattern, and it would give you a ranked list of potential causes of action with associated confidences, kind of thing, okay? But specific to Watson for Healthcare, one of the things we have to be careful of is, can the algorithms actually perform the way that the vendors say they do, the way that IBM is touting it? And for Watson for Healthcare, in fact, because there were so many problems with the output of the algorithms, the doctors lacked confidence in Watson for Healthcare, and they've stopped using it. MD Anderson will no longer use it. Okay. So let's talk about now the algorithms that we're seeing in law. In the same ways that algorithms are more and more starting to disrupt finance and healthcare, in law, they're being used to govern populations, okay? The data and the underlying algorithms are used to understand, analyze, control, direct, order, and shape society. That's a big deal, right? Because of this governance relationship, it's not a relationship simply of market profit like Wall Street, right? The obligations become arguably fiduciary, where without algorithmic accountability and transparency, the very people who create laws to govern society cannot act in their fiduciary capacity. We're unable to act in our fiduciary capacity because we don't know how the algorithms are working. So in law, to date, we have expert systems that have been developed for use by attorneys working in nearly every sector, from bankruptcy, immigration, estate planning, food and drug safety, securities matters. These expert systems, in some way or another, are evaluating input against existing information, including what is being touted as including legal rules and analysis, drawing inferences, making conclusions and recommendations, and some are even touting themselves as being able to provide the requisite reasoning. Okay? So we can see, you're gonna see folks from Ravel, Casey from Ravel, he's great, Pablo from Casetext. I believe those two companies to be super responsible in this area. They understand, they don't over-tout what their databases, what their products can do. Some other products, not so much, right? So we see Ross in the middle. How many of you, all of you have heard of Ross at this point, right? What is being touted as a super intelligent attorney here? Have any of you actually used Ross regularly? How's it performing? Is it a super intelligent attorney? No, there's the baseline for us. Okay. We also have up here represented in blue is a database called Do Not Pay. Have you heard of Do Not Pay? You go to it, you type in a simple legal query. How do I get rid of a traffic ticket in Michigan? And it gives you answers and gives you forms and is supposed to be jurisdictionally specific. I haven't played around with it a ton. And of course, we have our old friends Westlaw and Lexis there. I want to talk a little bit about Westlaw Edge, as it were. So in the academy, we got access to this. I think faculty were in November and students were as of January. So backing up a little bit, we all know we use these databases regularly. Both vendors released a new search experience in 2010, right? Going from the classic experience. How many of you used the classic experience, right? I did too. I was right on the cusp of that. So we were talking about being really good at Boolean searching. And how many of you still in the databases use Boolean searching? I do all the time, and I still get seemingly more relevant results. More on that later. So we know the classic experience required Boolean, so our students had to learn it. It wasn't or the lawyers had to learn it. It wasn't so much as just putting keywords in a search bar. And Westlaw Edge, at least for the Academy, was released in late 2018, including its new search interface called West Search Plus, okay? And the way that it's being touted is West Search Plus, introducing the next generation of legal research. Get superior predictive research suggestions as you start typing your legal query into the global search bar. So just type your keywords in. We're going to give you a superior predictive research. Okay. It touts itself as applying state-of-the-art artificial intelligence technologies to help you quickly address legal questions for thousands of legal topics. And this is the problematic part for me, without needing to drill down into the results list. So ask what are the elements of premises liability in Texas, and it's going to give you a case that has those elements. And you don't need to go any further than that, do you? We all know that that's great and that's the answer and we can rely on that. No. There's so many, the way that what is the case that is being used? What is the case going to be used for? Is it going to be used to cite to black letter law versus make analogies to the facts for a particular element, right? So we all know as sophisticated users what the issues are, but the vendors are now sort of touting themselves as just rely on the top result. It's no big deal, we're gonna give you, and lawyers and law students want that efficiency. They would love to just be able to rely on the first case in the list, right? So historically, we all know that these databases have been considered highly reputable, and they are. Nearly every law student in the country is learning how to perform legal research on them. Professor Susan Neville-Mart, how many of you have read her article or seen it? It's a wonderful article. I am going to talk about it a couple of times. From that article, we know that the databases show a surprising amount of variation in the results list. So for the same search query, we're getting different results in Westlaw than in Lexis, right? And now we have users who are being told to rely on the top result in the list, even though there's significant variation across the databases on a particular topic. And again, we have just let the algorithm have a significant role in selecting the cases that it deems should advance the law. Okay. So I want to talk a little bit about natural language processing. How many of you have seen this natural language processing curve before? Okay, so Brian Shepard talked about it at AALL. Does anybody remember which meeting we were at then? They're sort of blurred together for me. But it's an article out of, he's a professor out of Michigan State University. And he talks about natural language processing and functions that a lawyer performs. So we now see that the legal research databases are making broad claims about efficiencies. And that's a great benefit when we think about the duty of tech competence, right? Understanding the benefits and risks of the associated technology. The benefit is the efficiency. But to understand the risk, we have to know more about natural language processing, the limitations in particular of natural language processing, how the computer, how the algorithm is able to, quote unquote, understand language, to determine, particularly in law, what is a relevant result for a particular query. And this is very difficult to do. The human brain is well suited for it. It's a very difficult thing to do for a computer. So we see this is the natural language processing curve created by philosophers and computer scientists, starting with 1950, going 2100 and beyond. The top line is the best path. So what they're anticipating is the best path for natural language processing. And you can see sort of representing those fits and starts in technological advances. So we have three components of natural language processing that the algorithms use to determine relevant results. Syntax is the basic rules of grammar. Semantics is the conceptual side of language, where you're starting to see a relation between expressions and concepts. Okay. Pragmatics is context-driven and narrative in nature. Okay, so we go from syntactics curve, which is considered a bag of words, to the semantics curve, which is considered a bag of concepts, to the pragmatics curve, which is considered a bag of narratives. There's my Michigan accent coming out for you. So we're currently, if you look at the timeline here between 2000 and 2050, we're sort of at the tail end of the syntactic curve. Siri and Watson show this. I don't know, over the last 5 years even, your phone, Siri has gotten much better at understanding what it is you're asking for. If you think back 5-7 years ago, the results that Siri would give you then, I don't even know if she's been around that long, the results that she would give you early may not be as relevant as the results that you're now starting to see. And so that's a representation of going from syntactics to the beginning of the semantics curve, where it's starting to understand concepts and expressions of language. But the pragmatic curve is going to be very difficult for machines to handle. So we have to understand sort of when will machines be able to understand the context-driven narrative type language. The law some of the law, at least, is going to be very hard for machines to understand because there's conflicts, gaps, and ambiguities. Okay? The more ruleified the law is, the easier it will be for a machine to understand. If you're talking about something like living constitutionalism, it's going to be much more difficult for a machine to get to that pragmatic level understanding of language where you have to understand the law in terms of the context of society at the time. Okay? So we've seen natural language processing make great strides in producing these artificially intelligent behaviors, but none of the current natural language processing frameworks, none of these current frameworks that we're using actually understand anything about what they're doing. They don't understand the actual words and the results that they're giving you. So it's no different than a parrot that learns to repeat words without any clear understanding of what it is saying. And in law, that's problematic because words make up the foundation of the law. It is currently a word pattern or text matching process for them. And this is problematic because we need to think about premature disruption, where these vendors are saying, type in a natural language search, type it in, we talk about natural language processing, keyword searching, type it in the search bar, we're gonna predict what it is that you want, and we're gonna give you the relevant answer that you need for you to rely on. You don't have to drill down into the list, okay? Some stakeholders will be convinced by that. Some lawyers will say, oh, this is so efficient that what do I need a law librarian for? The database is doing it for me. This is when we get to premature disruption. It's when the stakeholders replace the people before the technology is truly ready. Now, we're all at the front lines of this. We all understand the risks associated with this. So we have to educate the stakeholders. We have a responsibility really to educate the stakeholders at this point to avoid premature disruption. So for example, when we talk more about premature disruption, what about paralegals? The traditional view is that they perform more low-level functions that are ripe for automation. Now, I know a lot of paralegals, and I think they would say otherwise, but go get me this case. Find me a sample document. That's what the legal field views paralegals as providing. And now we're seeing the databases say that they're able to provide that functionality. Why do you need to pay the human when you can use us? What about young lawyers, this question of young lawyers? So if we start to automate all of the processes, all of the functions of being a young lawyer, say simpler functions, how do the young lawyers build the foundation and learn how to someday be senior attorneys without ever having performed those things? So just because the machine can do it in the short term, is it good for the long term for them to be able to do all of that? Those are questions we're grappling with right now, okay? Now, librarians, this is probably a little self-serving. I think somebody put it to me the other day, we're like cockroaches, which I loved, right? We're gonna be around forever. We're needed. We're gonna survive the nuclear holocaust, as it were. It's going to depend on the type of legal research that you're doing, obviously. We've all seen machines automate lower level tasks, finding a case by citation, by case name, using jurisdiction functionality. The digest has been wonderful. How many of you love using the print digest? Okay, we got one back there. Good on you there. So it's really gonna depend, but when we see research that's required to make the quote unquote best argument for our client, that takes more sophistication, more understanding of language. It's going to be much harder for a machine to be able to do that. But as you see on the previous slide, right, the mainstream view is that this interpretation might be mastered by the last quarter of the century. Here we are, 2100 and beyond, potentially these machines understanding pragmatic level understanding of language. What does that mean for us? This is my macabre joke that I'll be dead. So thank goodness, right? So we're going to need us, we're going to need lawyers, we're still going to need paralegals, but going forward, at least with stakeholder understandings, it's likely that there are going to be fewer of us, unless we do, as Michael said, and sort of branch out our skills, right? Do we become coders? Do we go start to work for the companies and work with the computer programmers that are creating the algorithms, those types of things? So let's talk more about the risks. And I hope that you all know these risks. I hope that this is just a review for you, but the risks associated with using the algorithms, okay? So natural language processing, we just saw, natural language processing is not ready to perform legal research, at least creative legal research, sophisticated legal research. But there are other issues like the lack of transparency that make the algorithms troubling for other purposes. So we go back to the duty of technology competence when we're talking about the benefits, the efficiency. Here we're talking about the risks. What is the risks of using the algorithms? Here, lack of transparency. We know that as a routine matter of business, these algorithms are proprietary. Google's not going to tell us beyond just a few things how its algorithm comes up with its results. Why would it not tell us? Because then there goes all of its money, the thing that makes it competitive in the market. So they're proprietary. We can't know how they work. And in fact, sometimes we're seeing there's this discussion that after the algorithms are programmed, they start to do their own thing, and even the programmers aren't totally sure how they're coming up with their results. So they literally become a bit of a black box. So we can't understand the quote-unquote thought process that the algorithm, the software has went through to retrieve the results. How can we provide good information if we can't understand anything about how it's retrieving its results? We can look at patterns, we can try to determine how it's retrieving its results, but we can't really know. And the ultimate danger for the unsophisticated user is that it looks objective, it looks competent, it looks like you're putting in a keyword and it's giving you a good result. No, people aren't testing it, people aren't asking questions. And in fact, we go back to Watson for healthcare. The doctors there demanded a decision tree. They wanted to see how Watson for healthcare came up with those diagnoses. What was the underlying evidence, the underlying research for those confidence scores that were created? Should lawyers be demanding a similar thing? We're starting to get to the point where I think it may be too late. When it was being developed, we really should have been demanding that transparency. There's also the issue of bias, right? These algorithms can be subject to intentional or unintentional biases. The programmers that are writing these algorithms are overwhelmingly white and Asian men. So we could be writing their even unintentional biases into the code that is providing the results. And we might see, for example, different advice based on a criminal charge if race or income are a variable. We're going to see an example of that in just a minute. Because, as mentioned previously, artificial intelligence algorithms falsely seduce us into believing that somehow the results are objective. It looks like if the machine is spitting it out, that it's better, it's more objective than what the human brain can do. And that's not true in all situations. So let's talk about an example. How many of you have seen this example, Brescia Borden and Vernon Prater? Okay, this is probably the most famous example. Have you heard of the risk assessment database called Compass? Okay, this is Compass. So I think there's no better example to really showcase machine learning bias than this. So Brescia Borden here, the black female, was running late to pick up her god sister from school. I'm going to tell you a little fact pattern. Running late to pick up her god sister from school when she spotted an unlocked bicycle. She picked it up, started riding it down the street, realized she was too big for it, dropped it. Not before a neighbor called the police on her, and she was arrested and charged with petty theft. Now compare her crime to Vernon Prater. He was picked up for shoplifting roughly $90 worth of tools from a nearby Home Depot. Prater was the more seasoned criminal of the two. He had already been convicted of armed robbery and attempted armed robbery, for which he served 5 years in prison, in addition to another armed robbery charge. Borden, she had a record too, but it was for misdemeanors committed as a juvenile. But something interesting happened when they were put into the Compass risk assessment database. So Compass is going to provide a result about the chances of recidivism for prosecution, sentencing guidelines, right? So the computer program in this case predicted the likelihood of each committing a future crime, and Borden, who is black, was rated at a higher risk than Prater, who is white. A few years later, we know that Compass got it backwards. The computer algorithm got it exactly backward. Borden has not been charged with any new crimes. Prater is now serving an 8-year prison term for subsequently breaking into a warehouse and stealing thousands of dollars worth of electronics. Okay. These risk assessment scores, these algorithms, are increasingly being used in courtrooms across the country. They are being used to inform decisions about who can be set free at every stage of the criminal justice system. Okay. They're used from assigning bond amounts to a defendant's freedom, and they are subject, as we saw here, to potential bias. Another issue with using algorithms blindly, relying on the results blindly, could it be malpractice? It hasn't been argued yet, we don't know, but could it be? So we know that there is a duty to understand the technology as adopted now in a majority of jurisdictions, but could it be malpractice not to understand the technology? So the question becomes, can relying on artificial intelligence, in this case algorithms, blindly, be the type of negligence and potential causation that leaves an attorney open to a malpractice claim? We know that malpractice, to rise to an actionable level of negligence, the injured party has to show that the attorney's decisions were not merely the result of poor strategy, but they were the result of errors that no reasonably prudent attorney would make. And now, after this presentation, I hope you think that no reasonably prudent attorney would use algorithms blindly without asking questions and testing the results. Something we might see in the future. Let's talk about the research habits of the generations to come. So I mentioned the Google generation, born 1993 and later. So this is going to become an even larger problem, again, that we're at the forefront of, either teaching, educating, stakeholders, etc. So we've got the risks surrounding the blind reliance of algorithms becoming an even bigger problem as this Google generation enters law practice. We're finding interesting information about their research habits. So we see that research indicates that over 90% of searchers do not go past page 1 of search results. And so we're talking about search results on Google. They will not go past page 1 of Google search results. And in fact, generally do not go past the top 3 results in the list. Anecdotally, I'm starting to see this with my students in the law school. Now we've got Westlaw Edge telling them not to even go past the top results in the list. This is all problematic. Okay? We're letting the algorithms do our thinking for us. And of course, the algorithms, why would the vendors not want that? It puts them in an interesting position going forward, doesn't it? So coming to the teaching question, you asked the question about how do we teach the students? So we know that most all law schools make it their mission, if not all law schools make it their mission to graduate competent, practice-ready lawyers who are able to ethically represent clients. As technology becomes a larger part of everyday life, the legal academy in particular must take an active role. Law firm librarians, if you're getting them after they've been to law school and they haven't had this training, and we have to start incorporating this discussion of the duty of technology competence, okay? So how do we teach them? One of the ways that I would recommend is actually following Susan Nevelow-Mart's discussion of teaching in her article. She provides exercises for the students to compare the results in the various databases that they're seeing. So you're providing them with experiential learning opportunities to understand the variation of results and then bringing in this discussion of what it means to blindly rely on those results, making them see that there is huge variation across the databases. Her article is called "The Algorithm as Human Artifact: Implications for Legal Research." So, do we need a code of ethics for programmers? This is essentially where my research is going. Now, there's been some discussion that regulating programmers will discourage innovation. But I think the time is now to start thinking about, do programmers working in law need to be held to a similar standard as lawyers in terms of professional conduct? I talk to a lot of programmers. I don't know, the local watering hole that I go to in Lubbock tends to attract quite a few programmers. So I'll saddle up to them at the bar and have a beer. And of course I start in, they're like, this is heavy conversation for... So I start to ask them, what type of code of ethics do you work from? And across the board, they'll say to me, you know, we talked a little bit about that in school, but there's nothing compelling us to act a certain way. And so now is it time for us to create this code of ethics for programmers, at least working in law? I don't think that we all need to become programmers. Okay, it's a good skill to have. There's lots of coding camps you can go to for a few weeks in the summer. I've had friends get great jobs just from going to those camps. But going forward, what we need to think of is that law needs to be more integrated. We have to be inclusive of non-legal professionals in our field. We have to bring in the programmers, the engineers, the data specialists. Some of us will become those, because the future practice of law is going to be much more integrated. That's all I have for you today. Thank you.